So obviously I posted this initial examination sort of tutorial session. It's intended to give you a bit of a heads up on generally on how to start preparing for the exam in terms of the sort of the way to study, some pointers as to what you might do in perusal, how you might actually tackle the exam substantively in the writing period of the exam, some types of mechanisms for preparing. I haven't gone into the detail on each of the individual questions. What I'm intending to do is I wanted to sort of set up that general framework now, and then particularly now that you've done the assignments, and I should say all the assignments that have been submitted, I've marked and returned the marks to everybody, and as at today. And then in a few weeks from now, potentially over this Christmas New Year period, what I'll do is I'll do another sort of exam preparation tutorial, Mark 2, which will be a bit more detail on the individual issues relating to the questions. And then we'll do, I think my intention is to do a Mark 3, which will be right at the end of the semester, interactive, whereby we're actually talking about the individual questions and the issues relating to those questions.
But how do we actually study for the exam? I realize that we have to read all the chapters and read the notes and everything, but how do we, I think the issue that I'm concerned with is when I show up to the exam, when I need to write an essay, I need to reference a lot of things. And how do we prepare that block of notes where we can actually reference and use it as a centre de gravité? What do you call it? Like an issue, like a center, and to go from there. How do we?
Yeah, that's one of the things that I talk about in here.
I don't know.
I would recommend for each topic that you create, or each module, if we call it that, each week, you create 2 or 3 pages only of the key points and the key things that come out of that week or that module, however so described. Not too much. And that then forms the basis of your knowledge for the course, and that you then revisit that information regularly, daily, in preparing for the exam, so that you might have only, say, 30 pages of information in total, and you revisit that information on a daily basis in that exam revision period where you're leading into the exam. And obviously you've got an initial indication of the types of questions that are in the exam in this tutorial, one essay question, and then a series of problem questions of which you have to pick from. But I'll be then giving you even more detail as to the relevant issues relating to each of those questions. But I suppose the reason I haven't done that already is that we haven't gone through some of those issues that are going to be relevant. So telling you about the issues now rather than a little bit later on. But this session here that's on Moodle now is a framework for how to study, which was what you're just asking me.
Yes,
so if you've already watched
I did watch the video. I guess what I'm concerned about is the weakness that I discovered that I have when I handed in the assignment. To analyze deeply the case. This is my first term at law school. This is my first term and the first course I take.
You shouldn't describe it as a weakness, because in fact it's the key learning process that you won't just you don't just learn in law school. In fact, it's your entire professional life in the legal system is that exact learning process, that ability to analyze and distill out the relevant information. So don't think at all that that's a weakness. Far from it. It's just the key learning point that for all of us, myself included, throughout our careers, we are developing.
Yeah.
And I think generally, if I can make a comment about the assignments, I thought they were generally done well, and the marks reflected that. The range of marks were generally good marks, good to very good.
Mm. Yeah.
All right, we'll talk. That'll be something that obviously we're going to revisit, as I just mentioned. But let's go on to talk about topic 6, which is the intrinsic material. So obviously we've been looking in the last few weeks, and it feels like a long time ago in the sense that we've just had the break, but we've been looking at this idea of extrinsic materials, and we were focusing on purpose. But now we're turning back and looking inside the Act again, intrinsically within the Act or within the relevant Act in terms of interpretation. What is it that we can identify within a statute that might assist us in working out what specific sections and words in sections mean? In terms of some key terms, intrinsic, obviously, in the alternative to extrinsic, within the Act, material within the Act or information within the Act that might help us to work out the meaning of specific words or sections. Leading provisions, there might be some key provisions in the Act which are very important and which help us to understand the meaning of other provisions. So, for example, there might be a part of an Act, and at the commencement of that part or at the start of that part, there might be some key sections that tell us effectively what the rest of the part is focused upon. When I was reading through this stuff, preparing for what we're doing now, I was thinking about a case that I did a couple of years ago. It's probably 3 or 4 years ago now, where we were interpreting the powers of a government official in a specific set of circumstances. And it was relating to an insurance claim and whether this government official could require of the insurance company specific information relating to the insurance claim. And one of the things we had to do, there was a specific section we were focused upon, and of course we then analysed that section in context, in that part of that Act, to see, well, how does it change? And when you read the section specifically, I must admit I had a completely different interpretation of that section from the interpretation that I had when I read that section as part of that part of the Act, or that chapter, if I call it that. So, and in fact, that's what the court did, of course, and it coloured the outcome that the court gave to the conclusion. And in fact, they limited the powers of the government official administratively based upon the sections in that part of the Act. A preamble, and there's been much discussion in recent times as to a preamble for the Australian Constitution, but it's an introductory statement at the beginning of legislation that describes the purpose of the legislation. And obviously, a preamble might give you a heads up, if I call it that, as to what the legislation's focused upon and what its intention really is. Short title, we see short and long titles for an Act. I remember when they were changing the University of Queensland Act. For each of the Queensland universities, from recollection, there is legislation specifically about that university. And I remember there was much discussion because the University of Queensland Act, they were going to change the short title and the long title of the Act to remove the, because it was the University of Queensland Act, and they wanted to change it to University of Queensland Act. And of course, people were saying, oh no, we want to keep the as the long title. So it's interesting how little things can make a difference. So we're looking at intrinsic material. we're focusing on this idea of leading or subordinate provisions, that there might be particular provisions in the Act which will assist us in, by virtue of the fact that they're leading provisions. And if we've got a leading provision, let's say at the start of a chapter, the other provisions would then, of course, be subordinate to that leading provision. And how we might read sections within those subordinate sections will be dependent on the leading provision. Once again, I think I mentioned it last week, these aren't phrases that you'll see judges using a lot, if at all. This is an analysis academically of the situation in terms of what is occurring, rather than the phraseology that you'll see a judge specifically using when they interpret a piece of legislation. I think it's fair to say for much of the things we learn throughout the semester, they're not things that you'll see the judges using in the way they draft their judgments, but they're things that you'll see reflected in the way the judgments are actually getting to an outcome. There's a mention here of a High Court case, Commonwealth Law Report's decision, Project Blue Sky Incorporated and the Australian Broadcasting Authority. In that case, the High Court was considering the requirement as to Australian content in Australian television. So if there's a requirement that an Australian television station or network show a certain amount of Australian-based content, what is meant by Australian? So you can see there's some interpretation required as to what is meant by each of those things. What's Australian content? Is Australian content where a US show is edited in Australia, or bits of the show are edited? If 60 Minutes is using part of a 60 Minutes show from the US, is that an Australian content? Because it's been reconstructed into an Australian current affairs show here. And this case was obviously focusing on the Australian Broadcasting Authority as one of the parties. So the judges needed, in that case, they needed to determine which parts of the relevant legislation were subordinate to the other parts. Reconciling conflicting provisions will often require the court to determine what is the leading provision and what is the subordinate provision. And the reason this case has been mentioned in the notes is that it is unusual in the sense that the judges will get to the point where they're actually analysing it and using some of the terminology that we learn as part of, the structured academic approach to the question. So there is a hierarchy. Some provisions are more important than other provisions. And if they are more important, then we need to rely upon those provisions as a key way of interpreting the subordinate provisions. So the first question then is saying, well, if there are subordinate and leading provisions, what constitutes the Act? What is the boundary as to what is the Act? For example, if an Act has an explanatory memorandum, is that part of the Act, or is that intrinsic to the Act, or is it separate from it? If the Act has schedules, are those schedules part of the Act or not? And that's what this part here is talking about, part of the Act or not. I mean, obviously, Parliament wants us to be very, very clear about what constitutes the Act. You might have seen much discussion recently involving an interplay that occurred between the legislature or members of the legislature, who are also members of the executive, and some of the judicial officers. So it's very important to be clear about what constitutes the legislation. And once you can determine that, obviously then there's the ability to interpret it. The Commonwealth have included Section 13 in the Act's Interpretation Act. So they've said quite clearly, this is what constitutes the Act. All material from the first section of an Act to the end of the Act if there are no schedules. So it's first section to the last section. So what's significant about that is, if it was just that first subsection 1, if you can see my arrow, then obviously the long title would not be included. If the objects clause didn't have a number, it would not be included. A preamble would not be included. If there was some proclamation or gazette of the act saying this act is an act made on such and such a date, that would not be included, etc. The other thing that's significant about this is it says from the first section of an act to the last section. So does that include notes? Because Parliament often includes notes in an act. Sections are separate from the notes, little notations at the end of sections. So there's a range of questions that arise. And so to answer some of those questions at least, subsection 2 says, well, the long title is part, the preamble is part, the enacting words are part, any headings are also part of the act. But there's always going to be some uncertainty, and I gave you that example, little notations that might be included in an act. Those notations at the end of a section, then there's some question as to whether they form material that is part of an act. I should say those notations or examples, Commonwealth legislation doesn't have anywhere near as many of those as the Queensland legislation does. So you can see that's a fairly broad definition in the Commonwealth Act. When some of these things seem quite straightforward, but it can become quite complicated. For example, if there is something in the example which changes the meaning of a section, an example that's at the end of a section, we do need to be very careful in looking at that and saying, well, is that part of the act as such? And you'd think it would be. So what your notes do then is they go on and they start to look at some of these individual concepts. So the long title, and they call it a long title, but all it is a bit of an articulation as to what the act is about. Often, it's not a preamble. It's not. This is what we're hoping to achieve. It's this is what this act is about. This is an act for the purpose of, or not even for the purpose. This is an act to do something. It's an act to establish the Human Rights Commission, to make provisions in relation to human rights. It's an act to regulate property agents and motor dealers in the state of Queensland. Something like that. And they obviously give the example of the Australian Human Rights Commission Act. This is what this act does. It establishes the commission. It makes provisions in relation to human rights and equal opportunity as to employment and related purposes. So, and they make the good point that right at the end of this long title, which you'll notice it doesn't have a section number, it's separate from the sections of the Act, it goes before those sections. There's this phrase, and for related purposes. So it's expansive in that sense. It's not narrow in the way that it's defined what the Act does. It explains the legislation, and it says that there's potential circumstances where the legislation can do things that aren't just about creating a commission and aren't just about human rights in relation to equal opportunity in an employment situation. So if Parliament was to add some sections in there, they'd potentially be covered by this idea of for related purposes. Short titles, well, you can see an example there. It's from the same Act. You can see it just doesn't say, it's really just describing what the name of the Act is. So this Act may be cited, referenced, as the Australian Human Rights Commission Act 1986, and normally you'd reference that with, after 1986, you'd go open brackets, CTH, close brackets, to say, well, it's a Commonwealth Act, and that's its title. And normally I should say, they've done it there, but normally it'd just be the name of the Act in italics, and then the year of the Act in normal font, open brackets, capital C, little t, little h, close brackets, in normal font as well, to signify that it's a Commonwealth Act. So the short title is important because it helps you in a referencing sense to know what the Act is, or to know what its formal name is. They mention here a case of Osland and the Secretary to the Department of Justice. Once again, High Court decision. Justice Kirby, who was then on the court, he's now retired. He referred in that case to both the short title and the long title to affirm the purpose of the Freedom of the Information Act. So he was saying, well, look, we need to work out what's this act about, and his starting point was, what's the act called in a short title sense? What's the act called in terms of a long title sense? And I'm sure when you read that case, you'll find that he goes on to talk about other decisions, other sections in the Act, but that's his starting point. His starting point was to say, in a stepping stone sense, in a methodology sense, I start with the name of the Act in a short title, the name of the Act in a long title, and off I go. Preamble. So you don't, and this is the point they make right at the commencement here, this idea of a preamble is something which isn't being used as much now. And that's because the draftspersons, the drafters of new legislation, are hesitant to put a preamble in because they're conscious that the preamble may be used to, in argument, to encourage an interpretation that wasn't really intended. And so they're quite reticent now to include preambles because they're worried that that might change the interpretation that is given to specific sections, even though that wasn't the intended consequence of the preamble. A lot of old legislation will have quite lengthy preambles that don't necessarily make a lot of sense when you read them today. When I say old legislation, I mean legislation from the 1800s and the early 1900s. Lengthy preambles which are broad-brushed and which don't tend to say a great deal specifically. And obviously, as we were talking about, there's been a bit of discussion recently about adding a preamble to the Australian Constitution and about the legal impact of doing that. What might be the impact of it if it was added? And they're just reinforcing what I was just saying, that in modern legislation, only 17 of the acts passed in the last 25 years contain a preamble. As we've discussed in recent weeks, there is a real focus to have an objects clause in current legislation rather than a preamble. A purpose clause, if I call it that. What is the object of the Act? They say that this text here says that the objects clause creates a flexible way to explain the legislation. I wouldn't have said flexible. I would have said it creates a mechanism by which the draftspersons of a piece of legislation can articulate in the legislation itself the purpose of the legislation, the object of the legislation. And they're referring here to the Section 3 of the National Broadband Network Companies Act 2011. And I haven't looked to see whether that legislation's already been amended, but I'm just in conference, sorry. The objects clauses are a good place to start when looking at the purpose of the legislation, which is what I was saying before. And they do articulate the way the draftspersons have looked at a specific piece of legislation in terms of its purpose. They give an
Could this
example.
also be considered to be reading down,
So
where you're narrowing? I said, could that also be considered to be reading down, where you're actually narrowing an interpretation?
Yeah, I think so, but I'm just thinking about how that practically plays out. Normally, the objects clause is broad enough that, in fact, you can use it to say, well, look, if you look at the object of the whole act, it's intended to achieve this outcome, and when you read this section, surely it was intended to achieve X, Y, Z. I think that it tends to enliven arguments or to expand arguments that can be raised about legislation rather than narrowing them. But it certainly probably favours the legislature's interpretation, because it's their articulation of what they want the act to achieve. And I suppose that's your point, John, that it's giving them allowing them at the very beginning of the act to say, here's our focus. If you come outside that focus, your interpretation won't be as good as ours. So they mention here this Municipal Officers Association of Australia and Lancaster, which you'll see there, it's a federal law report, so it's a federal court case. The court gave consideration to the objects clause, but also said this clause may state the chief object, but it was still necessary to look at the rest of the act to consider the method by which the legislature implemented those objects. It is also possible for the court to read an objects clause in conjunction with extrinsic materials, and obviously that's something we've looked at in past weeks. That is, that the objects clause is assisting us in identifying the purpose, and in looking for the purpose, we might look at explanatory memoranda, second reading speeches, etc. The next one is the definitions sections. Now, this is where I find, in a practical sense, I'm spending a lot of time. So when I'm looking at the meaning of a specific section, often my first point of reference, even before an objects clause, before extrinsic materials, before other sections even in that part, I'm focused on the definitions section, because key words in a specific section will often be defined. And where you've got a clear definition about something, you're focusing then on the specific rather than the general. An objects clause might be general, but definitions as to specific words are very specific. I had a case in the last few months whereby there was a few phrases used in one of the sections, and I recall when you looked at the definition of one of those phrases, which seemed in context to be quite neutral, when you looked at that definition, it said the decision maker shall have absolute discretion, and that was the meaning. That was the definition of that specific section, or that phrase in the section. So what it was saying was something far more powerful than the words at first instance seemed to say. And the real danger with this is that you've almost got to double check all of the words in the section to see whether they've been defined. Not just defined in the definitions part of the Act, but maybe defined in other parts of the Act or in some definitions section included at the end of that chapter or that part of the Act. So you've got to be very careful about definitions, because sometimes it might not be clear that they're there. And then, of course, there are definition sections in the Acts Interpretation Act, in the general legislation about what an entity might, what is a person at law? Is that a company or a trust or a partnership or just an individual, etc., etc. They give an example here of the interpretation section, as it's called, but it could also be called the definition section in the Australian, or part of it, from the Australian Human Rights Commission Act. Sometimes the definition sections are at the start of the Act, and sometimes they're at the end. And often in Queensland it says, you go to say section 3, it says definitions, and then it says the definitions as to the matters stated in this Act, unless the contrary intention appears, are in Schedule 1 or 2 or 3 or 4 or 5 or 6. So in the sections of the Act, it refers to the definitions by reference to a schedule at the end of the Act. In this Act, the definitions are there at Section 3.
I have a question concerning the definitions. I'm sorry to interrupt, but in the textbook on page 100, they say that a definition where a word or a phrase where it appears a definition in one act cannot be applied to a word or a phrase where it appears in another act. And then in page 102, they say a definition may be expressed with reference to another act or even an international instrument. So should we use definitions in other acts or shouldn't we?
You should start by focusing on the definitions in this Act. You wouldn't refer to the definitions in another Act unless there was nothing in this Act that helped you in terms of definition. And what they're saying here on 102 is there's an exception to that, and that is if this Act says, look at the definition in another Act. The exception to that rule is the Acts Interpretation Act because it does apply to all other legislation.
Okay. So if only in the case where the Act says look at the definitions in another Act that we can use the definitions in another Act, or can we refer to them in cases where there is no definitions in the Act that we're reading?
You always focus on the specific rather than you always focus on the specific. So if you've got definitions in your Act, whatever Act you're looking at, look at those definitions.
If there aren't any?
If there aren't any, then go to the Acts Interpretation Act. If there aren't any there, then you might go to another third Act. It's another secondary Act. So, and that's what they're telling you at page 100 and 102.
Okay. Thank you for that.
So you might have, I'm just trying to think of an example, you might have the South Bank Corporation Act, 1989, Queensland, and you might have the Retail Shop Leases Act, 1994, Queensland. There'll be some definitions in the Retail Shop Leases Act. A word in there, I don't know what word it might be, shop, tenancy might be defined. And then you go to the South Bank Corporation Act and it might define tenancy as well. And you're dealing with a tenancy at South Bank. And you're thinking, which act do I apply? Well, the South Bank Corporation Act is more specific because it relates to South Bank than the General Act, which relates to the retail shop leases anywhere in Queensland. So you'd focus on the definition of tenancy in the South Bank Corporation Act.
Dominic, if there is a dispute about a definition, what's the ultimate authority on that?
As in, let's say you say that the argument as to the meaning of that definition is X, and someone else, another party, says that the meaning of that definition is Y, the decision will be made by a tribunal or a court as to what that section actually means, or what that definition.
So you wouldn't refer to, say, a legal dictionary then?
Oh, you do. And so that's exactly what we do. So we go through the stepping stone of saying here's what the Act says, here's what the Act's Interpretation Act says, here's what previous judgments have said, here's what Parliament has said, here's what the Department has said, here's what's happened in New South Wales, here's what's happened in England, and then you go before the court, you both put up your arguments on those meanings, and the court says, well, okay, in this set of circumstances as to this Act, this is what we say.
All right.
Yeah, and that's a big part of now of what we're doing. And
in which case, sorry.
Yes, sorry.
Sorry. I interrupted. I'm sorry. I just wanted to ask, in which cases do we refer to the Oxford Dictionary, for example? Because some of the acts that we read, they directly refer to the dictionary.
Some of the cases you're reading?
Some of the cases, for example, the Tilbrook case in the assignment, they actually look in the Oxford English Dictionary and the Macquarie Dictionary to define the meaning of violence. They didn't actually, they could have referred to another act, but they chose to look at the dictionary. Why?
Well, they had a specific question relating to that piece of legislation, and they obviously would have gone through, as they did, they went through, are there any definitions in this Act? No. Are there any statements by Parliament as to what this Act as to what this definition means? No. They would have looked at maybe an argument what was said in other acts, but if there's nothing that defines the meaning of violence in another specific piece of legislation and no indication that that definition is applicable to this Act, then the next step is to look at the dictionary type definitions, which is what they did.
Okay, thank you.
Yeah, and you can see they've just picked two key sort of leading dictionary, or the Oxford English Dictionary being the leading dictionary, long form, and then another sort of short form, as it's called, dictionary, Macquarie. So obviously, and we're jumping around a bit in this. We've been talking about these issues here, and as we were mentioning, you then go to the Acts Interpretation Act to see some other sections which sort of articulate how we're supposed to use definition sections, and 32AA in the Acts Interpretation Act says a definition in or applying to an Act applies to the entire Act. Now that there's a bit of a caveat on that, or a bit of a border on that, and that is that you can't apply it if there's something specific that says you don't apply it. So you need to look very carefully, and it does take a bit of time. I think one of the greatest dangers in all of this stuff is that when we're on it, it's a bit like riding on a subway. What I mean by that is, when you visit a city like London and you travel around on the tube underground, you don't realise that some of the stations are very, very close to each other, or the distances maybe from one line to another line aren't that far, and you don't get a perspective of what's going on above ground. I think the danger with using the internet and electronic analysis of statutes is that you go to one specific section, you jump and look at another specific section, you jump and look at a third specific section, and you're not actually getting a feel for the whole Act. And sometimes it is necessary, I think, to print out the whole piece of legislation and actually read it from start to finish, maybe not every word, but glancing through it all to get a feel for how the whole Act works, where specific sections are located, how they fit into place in the Act as a whole. And there's a real danger in the modern context in the way we search for things that we'll go to a specific section in one Act and we don't actually traverse the whole of the Act, if that makes sense. They give an example here of Kelly and the Crown. So this was a criminal case, went to the High Court. It's mentioned at page 101 in terms of the function of definitions in legislation. Justice McHugh, who was also a High Court judge, now retired, he said in that case, the function of a definition is not to enact substantive law, it is to provide an aid in construing the statute. So what they're saying is you're not punished by a definition, you're punished by a specific section, let's say, in a criminal context. If I or anyone else, unlawfully kills someone, that's the punishment section. Then there'll be definitions as to what unlawful might mean or what killing might mean, etc. All right. Well, let's move on to this idea of exhaustive or non-exhaustive. An exhaustive definition is obviously a broad definition. It's a complete definition. It's very hard to provide a complete definition because obviously it's impossible to be perfect in a sense. Another way of, you'll see the word code. So in Queensland we have a criminal code. What they're saying there is we've got an exhaustive articulation of all of the criminal offences in Queensland, as opposed to non-exhaustive being the opposite. That is, it's not a limited range of possibilities. So in the criminal law, we want to know what are the things we can get into trouble for criminally, and that's why we call it a code. So it's exhaustive in that sense. But in other areas, they're not exhaustive, or other statutes may not be exhaustive. So where you see means or includes, means is exhaustive, whereas includes is non-exhaustive. If something includes. So they give the example of the Witness Protection Act 1994, not an act I've had any familiarity with because it's really criminally focused, and they talk about, and we get this first introduction here to iustum generis, which is a Latin maxim, which you'll see every now and again different Latin maxims being used or Latin phrases because they help us to describe a lot of information in a short way, in a couple of words. And iustum generis is the idea that a definition will be inclusive. It includes, the general might include the specific. And we're going to come back to that in due course. So just appreciate that there might be a set of definitions. So we might say cows, sheep, and other farm animals. So the first two words are helping us to articulate what the meaning of the last two words might be. Iustum generis. Headings. We've mentioned headings a little bit earlier on, a couple of times, but what we're talking about with headings is that in each part, chapter, section, there will be headings, and maybe subheadings, division headings, part headings. Those, often there used to be a question as to whether those headings, whether they helped us to interpret what that section meant or what that part meant. And there's always been, certainly for as long as I've been involved, rules in the Acts Interpretation Acts about the weight or otherwise to be given to the headings or the part headings or the chapter headings. And now it's taken that those headings, generally, that those headings are important in interpreting the meaning of specific sections. And in different states and territories, though, and this is this point here, headings are treated in slightly different ways. So you do need to be careful in terms of the jurisdiction you're in and how that might play out. Schedules. So that's at the end of the Act. They tend to have a schedule or schedules. And I mentioned before, sometimes the definitions are in the schedules at the ends of an act, they tend to have a lot of information that maybe isn't put into the act. The difficulty, I think, is, for example, the Australian Consumer Law, it's called. The Australian Consumer Law is actually a schedule to the Competition and Consumer Act. So the guts of the Act is in the schedule rather than up in the Act itself. So you do need to be careful, I think. We all need to be careful when we're reading an Act that the schedule isn't in fact where we need to go. And if you're looking for the Australian Consumer Law, it's not easy to find it because it's there in the schedules to the Competition and Consumer Act. And the reason I mention it, it used to be called the Trade Practices Act, so people had a great deal of familiarity with that act, and it's not that easy to find some of the relevant provisions now. They are in the schedules, or in the schedules to that act. Right at the start, remember I was mentioning notes, and I was saying that there might be this issue where there might be notes in the margins or below the actual section that might impact quite significantly. It might say, for example, a person driving a car in such and such a way would commit an offence under this section. Well, that example might have a very key role to play in the way you actually read the section above. And the Queensland legislation uses these notes quite a lot. It doesn't use footnotes. They tend to be little notes underneath the section, and they're in a different font, smaller, maybe indented in a different way. And it's very important to make reference to them, but you need to be careful because you need to double check the Acts Interpretation Act to see what it's saying about the impact or otherwise of the note. And in the end, the section dominates the note, the little foot. It's not a footnote, but it's like a footnote in the sense that it's smaller text below at the foot. Punctuation. Well, thankfully there isn't as much punctuation in older legislation. I remember we used to have the Supreme Court Act 1995 in Queensland, and that act, even though it's a 1995 act, what it did was it put together all of the pieces of legislation from the 1800s that were relevant. That act had very long old sections, and halfway through there'd be a comma, or there'd be a semicolon, or there'd be an apostrophe or something that might have had a significant impact on the way you interpret a specific passage of words. And so thankfully most of the modern legislation doesn't have as much punctuation as the old legislation does. And so it's not such an issue to examine the words before and after the semicolon or before and after a colon, or it tends to flow in a plain English way, a simple drafting way. We were talking just before about examples, and I was talking about them in the context of notes. It lists them here separately, and it gives you an example. It gives an example of an example, and here's the example there. If you can see my arrow running across it. Examples for paragraph C: contractors with the agency and their employees, volunteers with the agency, and students on work experience with the agency. And subparagraph C may apply to other persons who are not public officials of a company, public service agency, who have a contract or other agreement with the public service agency. So it's helping us to interpret what is the intention of this paragraph here. What's it meant to focus upon? Penalties. So this is an interesting point about, and it's not because I don't practice in the criminal area, it's not something I'm thinking about a lot, but that is where it says, for example, the penalty for this offence is a certain number of units or a certain period of time imprisonment, or imprisonment and a fine. Is that a maximum penalty? Is it a minimum penalty? is it the penalty that the court must impose? We haven't traditionally in Queensland had a lot of mandatory provisions. That is, if you do this, you get punished with this much. So that's not the standard. The standard is this is the maximum. From 0 to maximum, this is the possible range of punishment. The Commonwealth Crimes Act section says penalties, well, except so far as the contrary intention appears, whether pecuniary or otherwise, a penalty indicates that the offence is punishable by a penalty not exceeding. So what it's saying is that's the maximum. Anything from 0 or from nothing to the maximum is the range of acceptability. All right. So that's a bit of a snapshot of this week. I'm going to turn off the record now.